Good evening,
Good evening.
Mr. Chairman and members of the committee. I'm attorney Maria Pierrot Fusaro, and thank you for this opportunity to speak before you this evening. I'm here today to testify and present testimony on the legal reasons why both H5125 and H5127 should not be codified into Rhode Island law, and why these bills should be voted against. You should have in front of you a memorandum that's written by Paul Benjamin Lynn, who's an attorney who's an expert in this area. And what I'm going to do this evening is briefly highlight for you the major points of this memorandum. Overall, the proponents of this bill, as you have heard already, are claiming that by passing these bills into law, that current Rhode Island law would be codified and that the Constitution would be upheld under Roe versus Wade and the progeny of those cases. And I'm here tonight to show you that there's nothing further from the truth. What you'll actually see is that many Rhode Island laws would effectively or expressly be repealed, and this would not be in line with the current constitutional standards from Roe versus Wade and those cases that followed. It actually far reaches and goes well beyond the current constitutional standards. I'm going to begin with the impact on late-term abortion. Under existing Rhode Island law, under section 11-23-5A, a late-term abortion may not be performed unless it is necessary to preserve the life of the mother. Late-term abortion is defined in terms of viability, which you've heard this evening how that is determined by the doctor. Under Roe versus Wade and Planned Parenthood versus Casey, this was upheld as constitutional, and states are allowed to put restrictions on post-viability abortions. However, nowhere in these bills is this upheld. And I actually want to briefly revisit Section 3 of H5127, where it says that the state cannot restrict an individual person from terminating that individual's pregnancy after fetal viability when necessary to preserve the health or life of the individual. I just want to clarify, that does not actually restrict for another reason. So what this is saying is they must be allowed to have an abortion post-viability if someone's health or life is at risk. Okay, so you can't deny that, but it does not say that this is the only reason why. It does not actually restrict in that language any other reason. So what would effectively happen if this was passed is that for any reason, at any time, up until 9 months, a baby could be aborted. So basically, the day before someone's due date, they could go in and say, I'm decided to have an abortion at this time, and that would be completely viable and legal with this language that you have before you. I hope that's disturbing, because it's disturbing to me. And in addition to that, sorry, excuse me, strike that. So to sum that up, this would not be in line with the current Rhode Island law, nor would it be in line with the Constitution, because as you know, again, as I've stated, the current cases allow for restrictions by the state, and we currently have these restrictions under Rhode Island law, but this law does not actually state that those restrictions would remain in place. So therefore, they would be taken away, repealed, and no longer recognized. The second is the impacts on the method of abortion, and this is specifically with regards to partial birth abortion. Currently, under Rhode Island law, partial birth abortion is illegal, and under current United States Supreme Court cases, we believe that this would be found constitutional from the 2007 Gonzalez versus Carhart case if this law was ever brought before as far as like whether or not it could be constitutional and upheld. So on this basis, again, currently in Rhode Island, the law is in the books banning this, and also it is found that this would be constitutional to have this ban. However, under both of these bills, we do not see this ban, again, expressly stated that this would not be allowed. There's nothing in there that expressly states this. Rather, what it does is has this, I guess you say, blanket language or so-called non-interference principle, which is set forth. And it says that the state may not restrict the use of evidence-based, medically recognized methods of contraception or abortion, except in accordance with evidence-based, medically recognized standards. So what this would do is basically, if we tried to say, well, partial birth abortion's not allowed, they could come forward and say, well, this is going to be, quote, interfering, right, with the method that is, quote, accepted at this time as a method. So therefore, without specifically spelling this out in the language, and due to this non-interference language, either expressly or impliedly, partial birth abortion would be allowed underneath this rule. So to revisit, we have abortion could be allowed at any point, at any time during 9-month period, and with any method. Now we also have partial birth abortion included. To continue on, this impact on regulation of abortion facilities. So another concern would be that under that non-interference principle that I was mentioning, the Department of Health or the regulatory agencies would feel that they're prohibited from going in and inspecting these facilities or really imposing any rules on these, abortion clinics, because, again, according to this language, this could be seen as, quote, interfering, right, with the woman's ability to obtain an abortion and restricting her right by imposing any of these regulations and bans. And therefore, this would be extremely dangerous because they would be pretty much able to, I don't want to say get away with, but not be required to follow these certain rules, or like I said, I think the department could be deterred from going in and actually imposing rules because they could be found in violation of the statute. And I just wanted to add that at the end, there is a little section under 23-4.13-2A, and it does state that, you know, this is not meant to, quote unquote, deter the Department of Health from going in and doing these type of things and imposing their standards and enforcing their standards, but the very last line then goes on to say, provided that such adoption or enforcement is not a pretext for violating subsection A of this section. So what that means is, even if they went in and tried to uphold regulations, they could say, well, this is a pretext. They're trying to restrict our right to an abortion here. And again, it would be another way out, so to speak, to not have any of the regulations imposed. Further would be the impact on Medicaid and other public funding of abortions. As you currently know, in Rhode Island, the cost of abortions for Medicaid-eligible women may be paid by the state only if they qualify under the Hyde Amendment. So this authorizes payment for abortions if the procedure is necessary to save the life of the woman or the pregnancy resulted from rape or incest. Also, there's a statute that says that under the Payers of Last Resort program, the elective abortions are excluded as a category. So right now, neither of these bills, again, they do not expressly uphold this Rhode Island law or keep it in effect. Also, this has been constitutionally found under the United States Supreme Court that the states have no obligation to pay for abortions for which federal reimbursement is not available. So you have, again, a Rhode Island law in the books that would be not held in place. And again, it actually far reaches from the current constitutional standard, which says that states are not required to fund these abortions. But then again, to reiterate that non-interference principle language, they could basically someone could argue and say, well, because I'm unable to afford this abortion, I am being restricted from being able to have an abortion, and therefore you must pay for my abortion. So that could easily be something that could be taken into effect with this very broad language. And there's also, under the 5125 bill, there's the parental consent issue, which right now under Rhode Island law, an unemancipated minor may obtain consent either from one of her parents or a legal guardian. This specific 5125 would allow for grandparents or siblings over the age of 25 to give consent. I just don't even know if anyone who's a parent, it just goes just beyond words, because this is a grandparent or a sibling certainly is not responsible for a child, so they should not have any means or right to make that type of decision, such a grave and large decision in a child's life for them. So this would certainly undermine parental consent. And there's also no constitutional authority for a grandparent or sibling to make any type of decision for a child. And the last, major issue would be the impact on the willful killing of an unborn child statute. Right now, under Rhode Island law, the willful killing of an unborn quick child by any injury to the mother or the child, which would be murder if resulting in death of the mother, is deemed manslaughter. In other words, an unborn child, if a mother is assaulted and the child in the womb is also hurt, is killed during this process, that would be deemed manslaughter. Effectively, through 5127 would repeal this law in its entirety. There's 3/4 of the states in this country have these type of laws, and if this was to happen, this would be the only protection that these unborn children have would be taken away, and there would be no law in place to protect them for a mother who is assaulted and the baby resulting in death. So I think that would be a travesty, and again, we need to think of these unborn children. We have done it. It's been in our books in Rhode Island, and it's certainly there's been no state or federal constitutional law that says, cases saying that this is unconstitutional at this time. So this type of law would be upheld. And also, there's other far-reaching effects that we just may not know at this time on other statutes that are very important to, not just the child in the womb, but like I said, it goes on to their parents, to the family, and by codifying these into law, what would happen is certain laws get repealed, certain laws get replaced, and whether or not it may have not been the intent. And it's like I said, it's being presented that these bills would not be extreme. I hope now that after going through what the effects of this bill actually would be, I hope that you disagree and see that in some these bills would not be codifying current existing Rhode Island laws simply as it's being presented to you, and it would not just be upholding the current Roe versus Wade principles. It would go far beyond that and be extreme. So we're asking that you please vote against these bills and know that this would devastatingly affect our state, not just now, but for years to come. And that is the truth. Thank you.